Hatti, and I lead the disputes team here at Samvad Partners. It's very exciting to have this conversation with the SIAC. The SIAC is no stranger to India. I have Kevin Nash and Shwetha Bidhuri with me. Just before we start, I'm going to do a brief introduction for both our speakers today. You're welcome to ask any questions as we go along. You'll see a chat box. Please type that in there, and we'll take questions as and when we go along. We will also have some time for questions at the very end. Before we start, the SIAC and India have a special relationship. In 2019, India was the highest caseload for the SIAC. The leading foreign country users, the SIAC annual report set it out. And so India sent 485 cases. The SIAC, of course, has dealt with more than 59 jurisdictions as part of their caseload in 2019. So with me today is Kevin Nash. Kevin is the Deputy Registrar and Centre Director of the SIAC. He's responsible for the administration of cases filed and the supervision of the SIAC's multinational secretariat. Kevin joined the SIAC in 2012 and since then has overseen the administration of many international cases under the SIAC rules as well as the Arbitral arbitration rules, amongst others. He has rich experience in expedited procedure, emergency arbitration, early dismissal of claims, and has also worked in the revision of the various SIAC rules over a period of time. Thank you, Kevin, for joining us. It's a pleasure to have you here. I look forward to it. Thank you. The other panelist today is Shwetha Bidhuri. Shwetha is the head of South Asia for the SIAC here. She's based in Mumbai and oversees the operations of the SIAC's offices in India. She's been instrumental in promoting the use of institutional arbitration across South Asia, and she's been enrolled as an advocate in 2007 and holds a Master of Law degrees. Shwetha has also been practicing prior to joining the SIAC, so she comes with a rich experience of a practitioner in the arbitration scene as well. Thank you, Shwetha, for joining us. It's a pleasure to have you on board.
Thank you, Poornima.
Lovely. So before we start, what I will do is I will ask Kevin and Shwetha questions and we'll have a chat. If either of you have any thoughts or want to sort of add on or comment on anything else that has been discussed, please feel free to do so. This is fairly informal and that's the way we'll keep it. So Kevin, I'll start with you. As we just discussed, you know, India is the top foreign user for the SIAC in 2019. So you're obviously seeing a lot of cases coming in from India from the international perspective. Do you see that as a trend going forward in terms of institutional arbitration from India continuing to opt for the SIAC? Of course, the Whiten case study also says the SIAC is sort of a leading choice internationally as well. So what are your thoughts on that, India and the SIAC, and why more Indians are opting for the SIAC?
Yeah, I guess as a starting point, thank you very much to you and to Samvad Partners for having us. It's great to be able to connect in these virtual ways during these challenging times. The relationship between SIAC and Indian parties really has been going on for a long time, and it is a part of a lot of outreach efforts, the excellent efforts by Shwetha and those people that have been overseas. But the thing is, with any marketing of arbitration, the services have to match the marketing. So we've attempted to liaise with Indian users, show Indian users the kind of case offerings that we have. There's a lot of very sensible reasons of why Indian parties would choose SIAC. It makes sense from a geography standpoint. It's very easy to get to Singapore and India. I think all of us have taken that overnight flight either from Singapore to Mumbai or Singapore to Delhi. So you're able to fly in on the day. You might have a hearing in Singapore and then you fly back on the overnight flight. Indian parties are also very comfortable with arbitration in Singapore. You have two common law systems. So if you look at Asia Pacific, there's a lot of civil law jurisdictions. So you have Singapore law, Indian law. These are both common law jurisdictions. Because we have so many Indian parties at SIAC, we've really looked at how we can tailor and customize our services for Indian parties, particularly in the revisions to the rules. Of course, we're always giving great effect to the needs of Indian parties. You can also see it with the composition of the SIAC Secretariat and the SIAC Court. So we have 2 Indian qualified counsel in the SIAC Secretariat. So as an Indian party, whether your dispute and contract is governed by Singapore law or Indian law, you're likely to have an Indian qualified lawyer. You also see it on the SIAC Court of Arbitration. The SIAC Court of Arbitration is the body responsible for the most important questions in any arbitration. So jurisdictional objections, consolidation, joinder, challenges to arbitrators. We have 4 Indian members of this very elite body, so they're able to give effect to the Indian position. One thing that I think is very interesting, and of course, on the assumption that 2 Indian parties can agree to a foreign seat, that has been left to one side for the moment. Not only are we seeing Indian parties with the counterparties that make sense, so Indian parties, Japanese parties, we'll see cases with Indian parties on both sides of the contract. And there's also a lot of flexibility. So it could be 2 Indian parties, Singapore seat, Indian law, of course, governing in that situation. Or you might see Indian parties choosing SIAC arbitration, a seat in Mumbai, and then venue in Delhi. So there's a lot of ways that you can customize these disputes. In terms of why SIAC, I think one thing that makes us feel very good about how many Indian parties are choosing SIAC, 485 Indian parties in 2019, just an astonishing figure, is that Indian parties in India as an arbitral jurisdiction are very sophisticated and they're very discerning. There is a preference in some circles to use ad hoc arbitration, so the choice between ad hoc arbitration and institutional arbitration is an important one. Also, when Indian parties are looking at the different institutions, I think that Indian parties in particular are looking at institutions that are really adhering to the fundamentals of arbitration. Because why do our parties go to arbitration to begin with? You want to have an award that is enforceable, that is going to be cost effective, it's going to be fast. And there's a lot of institutions around the world, and I think that Indian parties are looking at all the different institutions, looking at what matters to them, what an institution can do for them, and increasingly choosing SIAC.
Thank you, Kevin. I think those are all compelling reasons, and it's interesting to know that the Indian parties are kept in mind when you relook and revise your rules and customize arbitration truly. So that's an interesting perspective. Shwetha, if I may go to you now. So in terms of applying the SIAC rules to Indian parties, and you've practiced in India, so you know the ground reality and how course and Indian clients work in India. How do the SIAC rules help with saving time and cost? We already have an overburdened judiciary here, so the shift from arbitration to litigation should not happen again, and the reiteration of arbitration continuing to be a cost-effective method is a message that needs to be sent out again. So what are your thoughts on the SIAC saving time and cost for Indian parties?
I think first, to add to what Kevin was talking, and from my experience of interacting with Indian users, I have seen a substantial build of trust with SIAC, and I think that has led to further increase over the years because the parties have used SIAC and seen the difference in terms of the efficiency, that they're able to go back and like you say, by word of mouth, being able to discuss here and around of how their experience has really been. So of course there have been different contributor factors of why India has opted, a lot of Indian users place their trust in SIAC. But I think at the same time, it is the experience that SIAC has of Indian parties that also allows for more Indian users to feel that comfort and assurance of the efficiency within the system. Now going back to the different provisions under the SIAC rules that allow parties to save time and cost, I think the first very important shift that we are seeing within India is of course the most fundamental, from ad hoc to institutional arbitration. And, when you are already beginning to understand that why is it necessary to move to institutional arbitration, you're also looking to explore options which will allow you to truly utilize the efficiency of an arbitration. So within the SIAC, if I can focus on some of the most important mechanisms, one is the emergency arbitration, which I think in the current times is being even more prominent, than otherwise. The expedited procedure, the early dismissal, joinder and consolidation, and lastly, but very importantly, is the ARB-Med-ARB protocol. So I think all of them, and if I can just briefly, give you the key features of each one of them, really allow parties to be able to have significant time and cost savings. So beginning with the emergency arbitration, as you know, that how courts have, with the current pandemic, have restricted themselves to largely very, very urgent matters. And like in India, a lot of, on the criminal side or family related or something which is extremely urgent. So it's not possible for parties, in a commercial court, in a commercial matter, to be able to easily approach the court and be able to have a decision in a really quick manner. So I think emergency arbitration allows that option, for you to be able to have recourse, where you can have a decision when it's urgent in really like the shortest time possible. So within the emergency arbitration, you can have the emergency arbitrator appointed within one single day, and this is not even one business day, this is one single day, and have the order in place within 14 days. So the litigation will not give you that guarantee of timelines, but an emergency arbitration would do. And of course, I think we'll discuss this as we go along about how the enforcement of this is playing out in India. But in a nutshell, the Indian courts have indirectly given effect to the emergency arbitration's decisions. And we have some examples of SIAC's EA orders which have been given teeth to by the courts in India. So I think that also has made this mechanism very popular with a lot of parties, and particularly Indian parties. Second is the expedited procedure. And, to be honest, I think expedited procedure is just one of the most popular mechanisms amongst the many that we're discussing. And particularly also at a time like this, when liquidity is going to be a very significant factor that the parties are going to consider, where they would want their disputes to be determined, in a time-bound manner. So in an expedited procedure where you have lesser complex disputes, and maybe they amount less than about 6 million Singapore dollars, or where the parties agree, or there is an exceptional urgency, you can go opt for an expedited procedure and have the decision, in your hand within 6 months. So I think that, so when you save on the time, you also automatically save on the cost, because the longer you run in a proceeding, the more you end up spending. Thirdly, the early dismissal, also very interesting, given the current times where parties are likely to raise, grounds of force majeure and frustration, is where there is something which is manifestly without legal merit or manifestly outside the jurisdiction of the tribunal. You can get the claim dismissed at the outset without having to run the entire arbitration to the course. Again, then joinder and consolidation, which allows you to join parties, the related parties and related contracts in an arbitration, and avoid having inconsistent decisions. So I think very, very important tools which you don't have recourse to in an ad hoc arbitration. Lastly, ARB-Med-ARB. Of course, everyone's been discussing about the importance of mediation and how that's going to become very important in the coming times. But I think not just the mediation, but this combination of arbitration, mediation, and arbitration, where once the arbitration has commenced, that you can go back to mediation and try and settle the matter and then have the same effect that you would have in an award, is a very, very instrumental mechanism that will allow parties to have significant time and cost savings. So I think those who've been using these mechanisms can truly attest to how useful it has been.
Thank you, Shwetha. So I think there's a lot that you've discussed. You've talked about the expedited procedure. You've talked about the emergency process. You've also talked about, all of this adding up to costs from an ad hoc versus institutional perspective. So if I can just continue with that thread and go back to you, Kevin. So, if I'm looking at your rules and on expedited procedure, so, for expedited procedure to kick in, there's a lot which is at the discretion of the registrar. And I know that the rules, when we say registrar, includes the deputy registrar, which could come down to you. So when you assess and determine whether, and if parties don't necessarily agree, how would you look at it, and what would you treat as exceptional urgency? And what happens if one party doesn't cooperate, or there are multiple parties and they don't cooperate? And I know cost is very, very important to Indian parties. So how would you, just in terms of how would the Secretariat look at it, and what would be guidance for you?
Kevin, you're on mute.
Apologies. That's a great and very important question. To give some broad context, one thing that's been very exciting for me is that I'm sitting in the United Nations Working Group 2, where we're looking at fast-track proceedings. And because Singapore and SIAC have done so many of these expedited procedure cases, really a lot of the state delegations are looking at the Singapore experience, because we've had more than 500 of these applications. And you hit on the very important point that a lot of these applications are contested. And it becomes like that old lawyer joke where the applicant who wants fast-track proceedings says, this case is very simple, it won't require a lot of fact and expert witnesses, it's appropriate for the expedited procedure. And then the responding party may be opposed to it and say, no, 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 this case is very complex, multiple jurisdictions are involved, there's lots of issues of fact that need to be determined. The challenge for an institution is that you have to determine all of this at a very early stage. Because if you look at these factors that Shwetha mentioned, so the sum and dispute is under 6 million Singapore dollars, party agreement, or in cases of exceptional urgency, these are just threshold factors. So just because the amount in dispute is under 6 million doesn't mean that necessarily it will be appropriate for the expedited procedure. The most difficult one, as you mentioned, is exceptional urgent, because exceptional urgency in the context of expedited procedure is much different than an emergency arbitrator and a request for interim relief where you're looking to preserve the status quo. Effectively, the argument that needs to be made is something is exceptionally urgent to the extent that we need the award to be rendered in less than 6 months for these reasons. Something needs to be turning on the merits where the award has to be rendered. A lot of times parties will also make alternative arguments. So you could have a case where a party says this is a very simple dispute, it's under 6 million Singapore dollars. In the alternative, it's also exceptionally urgent. One thing that's important as well with the expedited procedure is there is a flexibility to go before a 3-member tribunal and a sole arbitrator tribunal. In the event that the arbitration clause provides for a sole arbitrator and the application for expedited procedure is not accepted, you can still be looking at the tribunal and perhaps expediting the timelines under the regular procedure. For us, exceptional urgency, I think, is the most difficult one. Most applications are going under on the basis of party agreement or the sum and dispute being under $6 million. But I guess the primary factor for exceptional urgency is something that has to happen within that timeline. As a final point on the expedited procedure, I think there's one mechanism under the rules that parties ought to consider using more, because it's not just 6 months. The registrar has the power to abbreviate the timelines for the award to be rendered. So a party could make an application and request that we need this award to be rendered in 4 months or 3 months. That's something that's perfectly within our power to do, and it is a tool that parties could consider using.
Thank you. Those are very interesting ideas and thoughts. So just to get a sense, how many are contested? Are half your cases contested on expedited procedure, or 70%, or just so that we understand the number?
Yeah, nothing public. I mean, most of these applications are contested. I think as it gets more and more popular and both claimant side and respondent side realize that this is going to cost significantly less, this is going to be significantly faster, and I think parties are more amenable to it. But most of the applications are on the basis of the sum and dispute, and they will be contested.
Thank you, Kevin. Shwetha, coming back to you, and this is more specific to the enforcement of emergency awards in India. We've had the Delhi High Court recently saying, of course, not in the context of the SIAC, but in the context of the Japanese rules, and we've had the Bombay High Court in the context of SIAC rules, where, for whatever it's worth, they still entertained the Section 9 application, which is really looking for interim relief, after a institution did look at interim relief through the emergency arbitration provision, right? So what are your thoughts on that, as users of arbitration, in terms of time and cost? Again, once you've had one go at an emergency provision or an interim relief provision, should courts allow for that to happen again and entertain again? And the Delhi High Court has commented and said that there should be no second bite on the cherry, as it were. Well, the Bombay High Court's observations were not that clear. So in that context, what are your observations? Do you have any thoughts? And I'd like Kevin to come back to see it from a comparative context, across South Asia, Southeast Asia, whether India's standing out as an exception in terms of enforcement of these awards. But Shwetha, first you.
Yeah. I think going back to Justice Sri Krishna's report, where he had, when the recommendations were made for amending the Arbitration Act, one of them was to be able to include emergency arbitrator in the definition of an arbitrator under the Act. But unfortunately, when the amendments had been rolled out in 2015 and now in 2019, last year, again, this is a point that was clearly missed. Which clearly explains that the legislature is not intended to cover this within the ambit. So from the legal standpoint, emergency arbitrators' decisions are not directly enforceable, which, as you would have seen, Delhi High Court's decisions, even the Raffles one and the earlier ones, where the court had specifically set out that within the current legislative framework, we have not provisioned for enforcement of an emergency arbitrator's decision. But in practice, I think there is an ancillary enforcement of the decisions made by the emergency arbitrator, which is an interesting point, because how do you make that commercial judgment that whether I should go for Section 9 or should I choose an emergency arbitrator's route? Second is, if I have to in any case go back to Section 9, why should I go for an emergency arbitrator? I think these are two very important considerations that a client would make. But like I said, briefly earlier, that how emergency arbitrator will allow you to have a decision in place in a definite timeline is one of the biggest factors why parties would consider to go down, to the route of emergency arbitrator. Not in every case where you've got a decision from an emergency arbitrator, you need to come in a Section 9 and try and give it the enforceability that you require from the court standpoint. There are many cases, which I'm sure Kevin will attest to, where parties are open to, there is a voluntary compliance by the emergency arbitrator's decision. And it's only in such cases where you apprehend that there would not be a compliance that you come in under Section 9. But even under Section 9, if we look at Plus Holdings decisions of the Bombay High Court, which involved an SIAC emergency arbitrator's decision, the court did not go into every detail of the case. And they did rely on the judgment made by the emergency arbitrator. So it was a significant consideration that the fact that the emergency arbitrator has looked into all of the details relating to the case and has passed an order. But from, like I said, to be able to give teeth to that order, they passed in a decision under Section 9. So I think from a strategic point of view, the Section 9 has an interplay with an emergency arbitrator from India's point of view, but not in every case that you would be required to. I'm also hopeful that with the next amendments, that may be considered in India, this is a lacuna that would be fixed, and this gap, which is currently existing, which will allow for emergency arbitration decisions to be even more efficient than in the way that it currently stands.
Thank you. Absolutely. I think we were all disappointed that emergency arbitration did not find place in the amendments that have happened, despite many suggestions for it to be there. Kevin, just wanted you to contrast that position with other jurisdictions in India or around the world where you may have seen a greater recognition of an interim relief that's been granted through the SIAC process.
One of the exciting things is that is it does actually tilt back to India, because in terms of emergency arbitrator jurisprudence, when you look at the decisions in Delhi and Bombay, the India jurisprudence is probably the most compelling on emergency arbitration than any other jurisdiction. I think that the world and SIAC in particular are looking at these judgments. The situation's a bit different in Singapore because orders and awards of an emergency arbitrator are enforceable as an order of the High Court. So this is both for Singapore-seated arbitrations and foreign-seated arbitrations. We know anecdotally from reports that that courts have given orders in the same terms in other jurisdictions, United States being one of these jurisdictions, but this is part of the commercial decision that Shwetha is discussing. Emergency arbitrator provisions and the opportunity to go to court are designed to work compatibly. So you have to make a decision. What is the exact nature of the relief? The Singapore International Arbitration Act makes it quite clear that you can go to court when the institution is unable to act effectively. So for instance, if you needed an order against a third party, for whatever reason, the circumstances were such where you needed ex parte relief, then you might make an application, say, to the Singapore court if it's a Singapore seated arbitration. But as Shwetha rightly points out, if time is of the essence, there is no place that you can get a faster order or injunction than you can with an emergency arbitrator. It is starting to be a very old joke, but these applications do come in on Friday night. You can make an application at 11 p.m. on Friday night, have an emergency arbitrator up and running on Saturday morning, perhaps a preliminary order on Saturday afternoon. There are very few, if any, courts in the world where you can do that. And I think even more so during this COVID-19 pandemic, we are certainly seeing an uptick in the amount of emergency arbitrator applications right now.
Thank you, Kevin. That takes me to my next question, since you brought up the pandemic. How has the SIAC adapted? Are you seeing more online arbitrations? Are you using any additional tools? I know you've run a series of webinars for audiences across the world where you've discussed, that large arbitrations need not be halted and they could continue to be run through, electronic means. Thoughts on that? And because people particularly talk about evidence being something that cannot be done online, and you need to see the demeanor of witnesses and things like that. So just thoughts on how are you sort of halting those? Is it working well? Message for India.
From my observation and in my view, arbitration as a practice has really been preparing for a situation like this for years. Many of our processes and procedures at SIAC are already automated and already online. So for us, from a secretariat standpoint, during the circuit breaker in Singapore, we were able to run the case administration with everyone working remotely without much of a disruption. What was happening most often in arbitration, you were already having, say, with virtual hearings, you would often have one or two witnesses that were participating virtually. The difference here now is that you have a hearing where everyone is participating virtually. One of the important questions for arbitration, and one thing that I'm seeing as well, is it's not just a case of necessarily replicating an in-person hearing. I think that what all arbitration stakeholders are looking at is whether it's necessary to have the same duration of a hearing, the same amount of discovery of witnesses. Are there ways to make it faster and more cost efficient? I think that the lessons that have been learned during COVID-19 of the availability and the efficiency of virtual hearings are going to carry over once we're back to the previous normal. Now, there's no doubt that there are still advocates and still cases, particularly where witness credibility is at issue, where they still want to see the whites of the eyes of the witness. You want to be able to react to the tribunal. How is the tribunal looking at this cross-examination? There are still cases where an in-person hearing is going to make much more sense. I have heard from arbitrators when they're discussing witness credibility that it's actually easier to assess witness credibility by virtual means because you have a camera that is very close to a witness's face, so you're able to see subtle differences in tone or mannerisms, and it can be easier. So virtual hearings will not make sense in every case, and that's exactly what we're seeing at SIAC right now. In some cases, the parties are agreeing, yes, this can be handled virtually. In some other cases, they're pushing it back to when they're going to be able to have an in-person hearing. I think the one thing that we're going to see probably as a matter of course, say for that first case management conference, in virtually every case going forward, this is probably going to be conducted by virtual means. No longer will parties want to go to the expense and time burden of all flying out for an initial meeting.
Thank you. I think that's a lesson that's been sort of learned across industries, across practice areas. Shwetha, there's a question that's come up on the chat group, and I thought maybe you could answer that. Sorry. What is the relevance of choice and governing law and jurisdiction under SIAC rules? I think this has been much discussed in various contexts in terms of how do you choose governing law and jurisdiction and the interplay between rules and the seat, as it were. I'll leave you to take that question. Thank you.
I think before I explain any further, maybe it will also be helpful to refer to Gary's masterclass on drafting of arbitration agreements, which he recently conducted, and it has been uploaded on SIAC's YouTube. And I think it's very helpful because it extensively lays down all the layers of drafting of arbitration agreement. But if I could just simply answer, what Shilpa has asked. So governing law, there are two aspects. One is the governing law of the contract and the governing law of the arbitration agreement. So the governing law of the contract will of course go on to determining the legality and the merits of the dispute itself, the substantive part. The arbitration agreement's governing law will determine whether an arbitration agreement is valid or not as per that governing law. It is up to the parties to choose either the same governing law for both the contract and the arbitration agreement, or they can also have it different. Then of course the applicability of SIAC rules or an institutional rule as you may apply in a contract will allow you that once the dispute arises and then arbitration takes off, that what are the rules that are going to be applied to the arbitration proceedings. For example, on the appointment of arbitrators and different mechanisms that we discussed that are available under the rules, the different timelines, there's the scrutiny of awards. So all the proceedings relating to the arbitration will be governed as per the rules of that institution. Interestingly, is the point of the seat, which will determine which courts will have the supervisory jurisdiction over those arbitration proceedings. So you could choose a seat to be Singapore or India, depending on what the parties really determine. And that would also be important when you have to set aside the award, which will be set aside in the jurisdiction where the seat is. So if you have the seat as Singapore, then you will go to the Singapore courts to set aside, or whatever supervisory assistance that you may require from the court in the arbitration proceedings itself.
Thank you, Shwetha. Shilpa, I hope that answers the question. So this is also a housekeeping announcement to say, if you have any questions, please feel free to type that in the Q&A box or the chat box, and we'll try and take them along as we go through the session. So Kevin, coming back to you, arbitration is all about party autonomy in some way, right? I mean, the way it's touted, at least, is to make sure that your dispute is before a tribunal that understands the nature of the dispute, and you have expert arbitrators who have a history of adjudicating such disputes, as opposed to being put before a generic judge in an Indian court who may not have the necessary expertise in similar matters. So what do you look for in an arbitrator? How much party autonomy is there to parties to appoint an arbitrator? Are we restricted as users to the panel that you have at the SIAC? Can we opt out of those panels? If you could just chat to us a little bit about that.
Sure. Yeah, I guess the appointment arises in ultimately four situations. You have the appointment of a sole arbitrator. You have the appointment of a co-arbitrator if one party's not participating. You have an appointment of the chair or presiding arbitrator, so that's the third and presiding arbitrator, and then situations where you might appoint all three arbitrators. But it is exactly as you say, party autonomy matters a great deal in arbitration, and I think more sophisticated parties are coming up with their own customized appointment procedures. We're starting to see situations where parties either in the arbitration clause or post-dispute, for instance, might want to have a list procedure. That's where candidates are given and then they're striked and ranked. Some parties prefer that to have a bit of a say in the appointment process. The overriding principle for institutions is anytime parties can agree on the arbitrator, that is the preferred course. When they can't agree, then the institution is called upon to make the appointment. One very big advantage that SIAC has in its appointments is that ultimately we're an institution based in Asia. We're an institution that understands Asia, and the appointment of arbitrators is going to be a critical part of the dispute. That is going to be the most important first step that will govern how your dispute will proceed. When we're appointing arbitrators, let's say it's an Indian party and a Singapore party, Indian claimant, Singapore respondent. The starting point is that we will appoint a neutral nationality. So if it's a sole arbitrator, it won't be an Indian arbitrator and it won't be a Singaporean arbitrator. If the dispute is governed by Indian law, it could be the case that we appoint an arbitrator that's resident in the United Kingdom. In terms of the factors United Kingdom, Malaysia, Hong Kong, in terms of the factors that we're looking at legal acumen and experience. We're looking at the seat and governing law. So what is the seat? What is the law of the seat? What is the governing law of the contract? Ideally, you want to have an arbitrator that's qualified in the governing law of the contract. You want to look at where each side is from. Is this an arbitrator that is going to understand the legal tradition and the culture of both sides? What is the track record with the institution? One big advantage that we have at SIAC is that we perform review of the awards. So we have very precise knowledge of the performance of an arbitrator. We also have an agreement with arbitrator intelligence, whereby at the conclusion of the proceedings, parties can send anonymized data on the performance of the arbitrator. While we're reviewing the awards, we also have our own evaluation. So arbitrators that are being appointed in SIAC arbitrations generally have a very positive track record for conducting arbitrations with expedition, efficiency. One thing that's very important that we're doing with the appointment of arbitrators, and I think that really we're doing about as well as anyone, is appointing arbitrators with diverse characteristics that match our very broad user base. So you mentioned that we had parties from 59 jurisdictions in 2019. It's well over 100 jurisdictions in the last 5 years. And you have to appoint arbitrators that match that very broad and diverse user base. If you look at our appointment of female arbitrators, we are steadily and increasingly closing the gender gap. We're appointing arbitrators from more jurisdictions. You do not want to appoint arbitrators just from a few European jurisdictions. That was the state of play maybe a few decades ago.
So in order to, is Poornima back?
Yes, thank you for filling in. Please go ahead.
Okay. So if you want to commence an arbitration, so first important is that what your arbitration clause says. So if it provides for an arbitration to be administered by SIAC, so you commence an arbitration by filing a notice of arbitration with the registrar of SIAC, accompanied with the fee. And of course, in the notice of arbitration, you set out about the dispute, the other party, the reference to the arbitration agreement, etc., and which details are given under Rule 3 of the SIAC rules. And you can access those rules on SIAC's website as well. And from there on, the procedure begins, where the other party is informed of it and the response is taken from the other side as well. And then the appointment of arbitrators, and then if there are any pre-arbitration applications, for example, for expedited procedure, or you need an emergency arbitrator, those are decided by SIAC. So really, in simple way, how do you commence an arbitration? It's filing a notice of arbitration with the registrar along with the case filing fee. Kevin, you want to add anything?
Just quite quickly. I mean, certainly you can be self-represented in arbitration, but you always want to get legal advice, and this is why, whether it's some partners, I think you want to consider representation. One thing that's very important, and what we've done through this COVID-19 pandemic, is that we actually have a live chat feature. So questions like this, where parties just want to be very sure, am I doing this right? As a neutral institution, we cannot give legal advice, but you do have international arbitration specialist manning the live chat. I actually, particularly late at night, I actually like to man the live chat. And so this will just be procedural questions on how do we file, what are your bank details, can we pay by overseas checks, can we still provide physical copies during COVID-19, all of these little questions. So I think having this live chat feature has been very helpful for our users, just to be able to quickly confirm before filing a notice.
Thank you, Kevin. I think anecdotally, I know many younger practitioners in India who've also benefited greatly from that chat. And I think it also reaffirms first-time users of the SIAC, just to make sure we're going in the right direction, sort of discussion. So that is very useful. Shwetha, can I ask you to chat a little bit about enforcement of arbitral awards in India? And you know, there is great resistance sometimes, and you also have to go back to the judiciary often. So while we can arbitrate, and there is, if there is no voluntary compliance, what then happens? And you know, what has your experience been?
I think from, of course, at SIAC, we don't track each of the enforcement of an award. But from what we are seeing in terms of the trend with Indian judiciary, there has, of course, been a lot more resistance to, you know, to get into the award or set it aside. I think over last couple of years, there's been a conscious trend that we are seeing with the cases where the awards have been upheld by the judiciary. But of course, having said that, you know, once you have an award, it is still a challenge to ensure that, you know, you have been able to enforce it within a considerable period of time and not have it prolonged for a very long period. So there have been some challenges, but from SIAC standpoint, there have been some decisions that I've seen recently, particularly of the Delhi High Court, where they have upheld awards, you know, given by an institution. And I think, you know, going back to the basic point of how even the courts are looking at awards which come from an institution like SIAC, of course, it goes down to the credibility of that award, and they are that more reluctant to, you know, to sort of disturb what the award has already decided upon. So yeah, so the trend, you know, from, you know, of course, the initial criticism that we had been seeing that, you know, it takes much longer. We're seeing a lot more interference by the judiciary. I think that seemed to have shifted considerably a lot now from the Indian judiciary standpoint.
Thank you. I think there's a question which is related, which says, how do you contrast that to other jurisdictions? Would either of you want to take that comment?
Kevin?
Sorry?
So the question is, how different is the situation of enforceability in other countries? So any thoughts, at least from a Singapore perspective? I know that compliance is much higher in Singapore in terms of, you know, and the interference from the judiciary is much lesser. So you actually see greater compliance, whereas that's not necessarily the case in India. Thoughts on Indonesia, Malaysia, Thailand, or anywhere else where, you know, the SIAC is active?
I absolutely echo Shwetha's comments. I think that there is a standard that comes with an institutional award, especially if certain courts are seeing many awards coming from that institution. What happens in Asia particularly is there's a lot of different jurisdictions with certain particularities, local requirements. The danger of a potential risk of an ad hoc arbitration or an institution that does not review the award is the award is going to be issued and there's going to be a lacking in that award that makes it susceptible to challenge. Because at SIAC, we review every award, we see and we're able to assist the tribunal on awards that might not otherwise be enforceable. Certainly, having seen thousands of cases, there are those awards that exist. Even still, the amount of awards that are potentially challenged at the seat or where there might be a party resisting enforcement is a very, very small percentage, particularly for institutional arbitration. But to me, it is quite critical to have an institution that has the review process for the award and an institution that has its awards being enforced in many jurisdictions. There, a very eminent Indonesian arbitrator, for instance, Pak Kiki Gani, did a survey of all of the international awards that had been enforced in Indonesia. SIAC had more awards enforced than every other international institution combined because we have lots of Indonesian parties. So to a certain degree, we've become an expert in the procedural requirements for enforcement in Indonesia. One thing that's important to emphasize, this review process that we have for the awards, this is not to change the tribunal's mind. It is still the tribunal's decision. What we're doing is we're making sure that the procedural requirements are taken care of to make sure that we've enhanced the enforceability of the eventual award. Most times, if everything goes right, particularly in an institutional arbitration where you have an institution overseeing the progress of the case, there will never be the occasion for a set-aside or for the parties to dispute on enforcement. And the vast, vast majority of cases, the parties will come to an agreement on the amount to be paid under the award, and it will never see or go to court.
Thank you, Kevin. I think even with India, there is hope that, we're sort of moving to the better side of things, and the judiciary is recognizing that they don't have to interfere in arbitral awards, both institutional and ad hoc generally, unless there is absolute need to do so. So fingers crossed there. Shwetha, just a thought in terms of large value, small value, does the SIAC make sense for small value disputes? Or, is there a threshold where you think it would make sense and then otherwise the cost is not worth it? Thoughts on that?
Yeah, I think very important to understand, and it's a question very frequently asked, is, does it make sense for smaller value? Of course, for larger value, there is a consensus that it's good to have an institution administer the arbitration to be able to control the escalating cost that may be in the case of an ad hoc arbitration. But I think even for smaller value, if you're able to utilize mechanisms like expedited procedure, you will be able to get that much out of an arbitration and not have your costs escalated as would be the case in an ad hoc. So I think the key is to be able to utilize mechanisms available under an institution effectively. And I think expedited procedure is really the answer if there are, lesser complex and or lesser value disputes. So it makes absolute sense even for a smaller value claim to be instituted under an institution arbitration.
Thank you, Shwetha. I also want you to take the question there, which is very technical, Indian law, Singapore law. So the question is, if both parties are Indians and the governing law is Indian law, but the seat is Singapore, then to what extent, I think the arbitral award is what is being asked. It's binding and enforceable in Indian courts. Do you want to take that question, because it's very specifically on Indian law and enforcement of Indian arbitrations in India?
So two things to understand from the fundamental standpoint. One is, where would you file for setting aside of that award? Second, where will you file for the enforcement? So where the assets of the other party is where you're going to enforce. So most likely, given that the two parties are Indian parties, they would have to come to Indian court to enforce that award, because the assets, the underlying assets against which you can realize the award would be in India. I mean, I don't see, of course, it will depend on each case to determine what are the factors that you can take into account if you want to challenge the enforceability of an award. But merely because the governing law is Indian law and the seat is Singapore, is definitely no ground for challenging the enforcement. So on this premise, it will pass smooth.
Thank you, Shwetha. I think we have about 5 to 7 minutes left. So if there are any questions, we'll take them. Otherwise, Kevin, my question to you is this the right time to start an arbitration? I mean, in these sort of times where industries are suffering, there is a global recession looming. What are you seeing? Is this the right time to start? Or should we wait? Force majeure is something that's been raised quite often. People are watching that space literally. So is this the right time to start an arbitration?
Based on our current caseload during COVID-19, it seems that lots and lots of people are thinking that this is indeed the right time to start an arbitration. I think SIAC, every institution, and the arbitral community at large, we didn't really know how this was going to go, but we are actually incredibly busy. I think what parties are doing is that they're effectively preserving their claim. They may be up against a limitation, so they're filing and then getting to talking. I think that this is a perfectly legitimate procedure, and ultimately as an institution, we want parties to be able to come to an amicable resolution if they're able. So filing a notice of arbitration, claimant files the notice, respondent files the response, and then they decide, wait a second, tough economy, neither one of us is particularly liquid. Maybe we should have a talk about this and see if we can reach a settlement. That happens in a lot of cases. You were mentioning force majeure. Obviously, there's a lot of performance or non-performance of contracts. One very useful thing at SIAC is that we do have the availability of the early dismissal procedure. So if it is just a question of the contours and the boundaries of the force majeure clause, that there's no question that one of the parties did not perform, and effectively the argument is, yes, I did not perform, I was not able to perform. This can be dealt with very quickly. So you can consider this question at a very early stage under early dismissal. Lots of the cases that we're seeing during COVID-19, these are contracts that were entered into and the dispute came before COVID-19. What has been very interesting is that now we have cases arising directly out of the coronavirus pandemic. I think everyone is thinking now that Singapore and other jurisdictions are starting to open up, we are going to see even more cases. So in terms of whether it's the right time, it is a bit case by case, but based on the caseload and my email inbox, it seems that parties from all around the world think that it's a very good time to be filing arbitrations.
Thank you. I think that's good strategy. I would agree with that. I mean, in India, the Insolvency and Bankruptcy Code has now some provisions suspended. So you could sort of go to the relevant tribunal here in India to sort of enforce your debt under the guise of the IBC. And with that suspension, if you had an arbitration clause, I would definitely advise a client to trigger the arbitration clause and send out their notices. So thank you for that. Just concluding remarks, Shwetha, what is the way forward for international arbitration? Are you positive this is the place to be, or do you really see other alternatives like commercial courts in India becoming credible options for commercial disputes at least? Thoughts on that?
Yeah, I think I'll go back to what Kevin said, that international arbitration had been preparing for times like these. I think for going forward, it is going to be a hybrid of the new times and the old times, and we will be able to utilize good of these new times. And I think it will, rather than looking at more as a challenge, it will add more to the value of creating even more efficient arbitrations, with the use of virtual hearings and use of technology. I think it is even more promising than before. Like we've always been talking about how arbitration inherently has the ability to adapt and to be flexible. And I think times like these have really proven that arbitration has stood up to it. As from where I see, I think it is going to be even more promising as a way forward, and even more contracts, the parties will now choose arbitration over litigation, and more particularly institutional arbitrations, because of the mechanisms that are available in an institutional arbitration.
Kevin, same thoughts. If you could sort of look into the future, a little bit of crystal glass sort of reading, if you could do on what steps, and do you see India continuing to send international arbitrations your way? Also thoughts on domestic arbitration picking up, or continued use of ad hoc arbitration, if you could contrast that and your thoughts on that.
Sure, and in terms of crystal ball gazing, Indian parties, of course, are going to continue to choose Singapore and SIAC, but I think that India as an arbitration jurisdiction is becoming more and more sophisticated. I think that you are going to see a very robust domestic arbitration practice. You are going to see some of the Indian centers starting to become more and more prominent. One thing that we've tried to do, in addition to, it's not just that we have Indian parties at SIAC, we've really tried to engage in arbitrator training, counsel training, thought leadership. When you look at the overall tenor of our events in SIAC, it's not to sell ourselves as an institution, it's to help build the arbitration bar in India. And there's lots of different ways that you can do that. If you look at the diversity of our appointments, that's something that we are more cognizant of the appointment of Indian arbitrators, not just appointing Indian arbitrators on cases involving an Indian party, say appointing an Indian arbitrator in a case involving a UK party and a Hong Kong party. if you look at the generation, particularly of young arbitration practitioners in India, this is a very sophisticated bunch. The quality of the pleadings and the filings and the advocacy that we're seeing from Indian parties at SIAC is absolutely top notch, and it's getting better and better. So it really is a symbiotic sharing between Singapore and India, where we want to help improve India as an arbitration jurisdiction and continue to offer our case management services to Indian parties as well.
Thank you. On that very encouraging note, thank you everyone for joining in, and hope you continue to stay safe wherever you are. Kevin, Shwetha, it's been an absolute pleasure. I hope to keep in touch, and good luck with all your endeavors at the SIAC. Thank you so much for joining in.
Thank you. Thank you, Poornima, for having us.
Thank you for having us.
Take care.